Hi, this is Myrna Arroyo with Myrna Arroyo LLC, and welcome to the workshop today, Estate Planning for Families. Don't leave your family at risk. So before we get started, I just wanted to give you a little bit of information about myself, and then I want to tell you a little bit about how this webinar is going to work. So this workshop is pre-recorded, so I originally did this live, so you're actually listening to a recording, but I will be available for questions. So if you have any questions about anything that I'm covering, feel free to send a message to me or an email, and I'll be happy to answer it. So my name is Myrna Arroyo. I'm an attorney here in the Baton Rouge area, practice law, licensed to practice law in Louisiana and Connecticut. I graduated from Tulane University in 1995 with my law degree and also an MBA. My main practice areas are estate planning, Medicaid planning, and business planning. So I love working with business owners and families to help them take care of this really important thing, which is planning for death and incapacity and passing on their estates to the next generation. So, to tell you a little bit of my background, when I graduated from law school, I initially worked at a big law firm in New Orleans and ended up moving to Connecticut to a different big law firm. And I did primarily tax law, which I loved and was very good at. But there was something about it that I didn't like. And what that was is that when I was practicing at the big firm doing tax law, I really didn't really get a chance to really have great relationships with my clients. It was very transactional work. It was a big hourly rate, and clients just didn't want to chit chat with me because they were paying, $300 an hour for my time. So in 2002, I decided to leave the big firm life and go out on my own and start my own law practice. And I focused in the area of estate planning because of a personal experience that I've had in my family. My grandfather actually passed away when I was 10 years old. And when that happened, it set off a chain of events within the family that did not go well because he did not have good planning. He owned several businesses and he owned some real estate in Puerto Rico. My mother was one of 7 kids. So, can you imagine 7 heirs trying to figure out what the best thing to do is with all of these properties and businesses? It was really difficult. It was really contentious. And as a result, I haven't seen a lot of my family members since that happened because my mother and her sister got into such a conflict that they stopped speaking to each other, and I stopped seeing my cousins, and it really split the family. It was really, really traumatic. And what I want to do with families in my practice is help them avoid that by being proactive and thinking about these things in a way that takes care of your loved ones so that you can have the peace of mind that that's not going to happen with your family. So what we're going to cover today is these 3 key points. Is one of the things one of my goals for today is to really teach you how Louisiana law works if you don't have a plan, because I want you to know what would happen if you do nothing, and then you can decide if you think that this is something that you want to change or not. I also want to address the simple form documents that you can download off of the internet and why those don't work, particularly because we're in Louisiana, and what you really need from an estate plan. And then I'm going to give you some next steps. So if you want to actually take care of this, I'm going to show you how to make that happen. So let's start with a little audit. So normally when families come to me for estate planning and they already have a plan that's maybe a few years old that they did with another attorney, I actually have a 50-point checklist that I go through to review that plan and make sure everything is in there that needs to be there. But because we don't have that much time today, I'm just going to ask you 5 key questions. And these are 5 big issues that can put your family at risk. If you answer no to any of these, then you need to come see me. So first of all is, if your plan has not been updated in the last 3 years, or you don't have a plan at all, then you're definitely going to want to listen, because I'm going to show you, I'm going to educate you on what would happen in those circumstances. Secondly, if you don't have an ongoing relationship with your lawyer that did your plan, this is another issue that can create a lot of risk for your family, because what happens with estate planning a lot of times is people treat it as a transaction. They go into the lawyer's office, they make the plan, they sign it, and then they take it home, put it on the shelf, and never look at it again. They just check that off the list and think they're done. But what happens is that life changes and families change, and you will buy and sell assets. You may have additional children. You may get divorced or remarried, your kids may get married. All these different life changes really should be factored into the plan on an ongoing basis. And so if you don't have a relationship with your lawyer, odds are that the plan you have has not been updated recently. The third thing is, do you have an inventory of financial assets? One of the big issues is unclaimed property. So in Louisiana, the State Department of Unclaimed Property, you can actually Google this to get the exact number, has over $580 million of assets in there. The way those assets end up in that fund is because people die, people move away, and they might have a little bank account somewhere, or they might have an old insurance policy that they forgot about. And because nobody is keeping track of this, when they pass away, there's no way for the heirs to know that they have this asset that they can claim. So it ends up being sent to the Department of Unclaimed Property. So the way you avoid that is by having an inventory. So this is one of the things that I'm going to talk about more today. Guardian nominations is another area of risk. A lot of times parents think that if they have a will that names guardians, they're done. But you have to keep in mind that that only works for death. What about during your life? What if there's an emergency and you need someone to take care of your kids temporarily? Do you have those documents in place? We're going to talk more about that today too. And then finally, coordination of planning between generations. And this is more of an opportunity than a risk. But when the parents have an estate plan and the adult children have an estate plan and they don't talk to each other, sometimes there's missed opportunities to really create amazing value for the family for the future. And so we always encourage our clients to be open with their adult children and their parents, if it's appropriate, as to the estate plan, so that you can make sure that you've maximized all of your planning opportunities. So now that we've done our little mini audit, and I hope you didn't do too bad, I'm going to tell you what happens under Louisiana law when you die or become incapacitated. So first thing we're going to talk about is incapacity. So incapacity is when you're determined by a doctor that you're no longer able to make your own financial or medical decisions because you're in a coma or your mind has gone. There's some sort of, usually it's it could be a mental issue that's making you incapable of taking care of your own affairs. So at that point, someone, usually a family member, will want to help you, right? So they'll say, okay, well, I can take care of this. I can make the decisions. However, under Louisiana law, you're not allowed to just do that. So in order for that family member to have permission to make those decisions, they would have to go to court and file an interdiction proceeding and get permission to make decisions for you. Interdiction is expensive and time consuming, and there's risks that the wrong people could end up making decisions for you. Maybe you have a really close friend that you want to be the person that makes decisions, but nobody knows that but you. And so when the time comes, your parents end up being appointed your curator to take care of everything. So the wrong people could end up making decisions for you. That's one of the risks. And the second risk is that the people who do end up getting appointed, they may not necessarily make decisions that are in alignment with what you would want, because they don't know what you would want because you never wrote it down. So these are some of the risks if you don't have a plan and you become incapacitated. When you die without a plan, different things happen. So the Louisiana law of intestacy is going to kick in. So if you're married and you have children in Louisiana and you don't have a will when you die, Louisiana is going to apply the laws of intestacy. And so Louisiana is a community property state. That means that, for most couples, unless they have a prenup or they bought property before they were married, pretty much everything they own is community property. So when one of them dies, the surviving spouse has her half of the community, or his half that they already own. But the property of the person that died that has to go through the succession process. That half of the property under Louisiana law goes to your kids. Your spouse has a usufruct for their lifetime, so they can still live in the house. If they rent the house out, they can collect the income, but they cannot sell the property, they cannot mortgage the property or do anything like that without getting the kids' approval, because the kids are technically the owners of the property too. So this is one thing when your kids are adults. But imagine if your kids are minors, if they're under 18, they don't have legal capacity to give you authority to sell the house or do any of that. So what you're going to have to do in that case is not only file a succession to get ownership of the property, but you're also going to have to file tutorship, a confirmation to be appointed tutor, so that you can actually make these transactions on behalf of your kids. So now you have to do 2 legal proceedings in order to deal with the property that was you and your spouse's. Imagine it's the family home, for instance. Not convenient. But this is what happens if you don't have a will. With respect to the separate property of that spouse that dies, that doesn't go to the spouse at all. That actually goes to the kids. The only time the spouse gets it if there are no kids. In any case, your surviving spouse is going to have to file a succession, may or may not have to file a tutorship in order to, and then you're going to have to deal with this ownership, which is not the most convenient for doing things, managing property. Now, if you have a will, you'll get a little more control, because of course in your will you can say who you want to get your property, and you could say, I want the house to go to my spouse outright so she can just own it and do whatever she wants with it. And I want these other assets to go to the kids, and you can actually plan it any way you want. You can create that in your will, and then the courts will honor that. However, again, just like with the not having a will, you still have to file a succession. You actually have to file a copy of the will into the succession records. The will gets probated. That's the probate process, which is basically making sure it has the proper form, meets all the legal requirements, and assuming the will is all good, nobody contests, the court is going to then award the property to the heirs. You can choose who your succession representative is in your will. We call them an executor. They actually execute the will. Again, that person has to meet certain legal requirements, but in general, most cases, that person will be the person that administers your affairs. So again, with the will, a lot more control. You still have to do a succession, but at least you can decide who gets your property upon your death. Talk a little bit more about the succession process and how to avoid it. A lot of people want to avoid the succession process because it's a pain. I mean, even though Louisiana doesn't have the worst, I mean, if you lived in California, you would definitely want to avoid the whole probate process. Here in Louisiana, it can take, you can get one done in 2 months if it's really simple. Average is like 6 to 9 months. Some of them go on to 18 months. And if it's really complicated, it may last years. Like in my grandfather's case, because there was so much conflict between the heirs, it actually took almost 30 years to settle everything with the succession, but that's really unusual. Successions are, they cost money, so you do have to pay for a lawyer to process all the paperwork for you. You have to pay court fees. On the very low end, it might cost $2,000 to do a succession, but if it's maybe up to 10,000 if there's a lot of assets, if there's a business, something more complex to manage. And a lot of it depends on how long the succession stays open and how many things have to get transferred. Assuming everybody is in agreement and there are no disputes about the will and there's no lawsuits, $2,000 to $10,000 is pretty realistic. However, if you have a situation where there is a lawsuit or there is litigation, then this number could become really high. Many attorneys do succession work on a flat fee. I mean, I try to as much as possible, but every once in a while there's a case where you just can't do that because there's too many unknowns. And in that case, you'll be paying hourly. So just imagine how many hours it's going to take to process this thing. The fees could be huge, conceivably. But assuming everything is everyone's friendly and everyone is professional and nobody sues anybody, you're looking at $2,000 to $10,000. Of course, your will has to be filed in the court, like I mentioned earlier, because it has to be probated. And as part of that process, it becomes part of the public record. That means anyone can go to the courthouse, pull a copy of it, read it, and find out all of your business. Some people care about this, some don't. I just want you to know that that's what happens. Your will is there, the whole entire succession proceeding is there, and it is a matter of public record. If you don't like this, if you would rather not have your heirs have to go through this, you can avoid it by planning in advance. So if you actually transfer all of your assets to a living trust during your life, then the living trust will transfer it to your heirs, and you can totally avoid all of this court filing and having to go through the succession. And we'll talk more about that later. Now I want to shift gears a little bit and talk about your kids at home. So if you have minor kids under 18, so and this is the question that I always ask parents is, okay, so think about you and your husband, you're out to dinner somewhere, and what if your kids are home with a babysitter, and maybe she's a 15-year-old neighbor. So imagine that you get in a car accident on the way home, and both of you are in the hospital, none of you are awake. The police, they look through your wallet, they see your address, they go to your house, they figure out that maybe you have kids, so they go to your house and they find your kids at home with the 15-year-old babysitter. So 15-year-old babysitter, she's not an adult, so she can't be the person in charge of the kids. If you don't have any documents that say, this person has the right to watch my kids, call them if there's an emergency. If you don't have that in a legal document, then the police are not going to know what to do. And in some cases, if they can't figure it out quickly, then they're going to have to report this to Child Protective Services. They're going to show up at your house. They may take your kids out of the home for a few hours or a day until they find the right person. So you can avoid this by having all of this documentation clearly stated in a place where people can find it. And you need to, and the key here is that you are naming not just permanent guardians for if you die, but you're naming guardians to step in temporarily in the event of an emergency. You have to make sure you give these people enough legal authority that they can take your kids and have permission to deal with whatever they need while you're in the hospital. And so Louisiana has the ability for us to create that. And that's part of what we do as part of our kids protection program. So if you haven't done this, then there is a risk there, right? That if something happens, there could be some uncertainty as to what's going to happen with your kids. The other thing I'll mention about this is with these temporary guardians, you want to name people that live close by. So if you're one of these people that your family lives far away, then you don't want to name them as emergency guardians because it's going to take them a couple days to even get to your kids, right? So you want to make sure you have some temporary guardians who live close by who can get to your house in 20 minutes and take care of things. Now, with your older kids in college, so if you have kids that are away at school, now they're adults, right? They're over 18. What we recommend is that you get a healthcare directive and power of attorney in place for them, because if you don't have legal documents that give you permission to access their medical records or their bank accounts, they're adults now, right? So you can't just go in as their parent and get access to this without court authority. So by having this paperwork done in advance, your kids can actually give you permission to do all of that. And that way, if something happens, you won't have to deal with, trying to get permission to do something for your child. You'll be able to just present your documents and take care of it. What about your parents? Your parents should have an estate plan too if they don't, because if they don't, then all the stuff I talked about that I'm telling you that your kids will have to deal with, you'll have to deal with it, right? So if they get incapacitated, you're going to have to deal with getting permission to make medical decisions. You're going to have to deal with making financial decisions for them. And you could get stuck in a probate proceeding after they die in order to get the assets transferred to you. You also lose an opportunity to create lifetime asset protection, because one of the things that your parents can do for you that you can't do for yourself is put assets for you in an asset protection trust. And that is something that if you coordinate your planning between the generations, you can actually create some amazing opportunities to grow your family's wealth over time. So I've kind of shown you the risks and I've shown you what happens when you don't have a plan. So now I'm going to tell you how you can avoid all of these bad things that I talked about. So estate plan documents. So I'm just going to go over the primary 5 documents that, a family with children would need. Of course, there's the will. That's usually one of the most important documents, and the living trust. I'm going to go into a lot more detail on those shortly. But there's also powers of attorney, healthcare directives, and kids protection plan. So I'm going to skip will and living trust for now because I have some slides just on that. But for powers of attorney, what I want you to realize is that, remember when I talked about when you're incapacitated, who can make decisions? They have to go to court. They have to get permission to act on your behalf. If you have powers of attorney, well, then that will give someone permission to act on your behalf. So they don't have to go to court. So this is a very important document to have. We usually create those where they're not effective until you've been shown to be incapacitated by 2 doctors. So somebody can't just take that power of attorney and spend your bank account and go to the Bahamas. It's really only if you're incapacitated that it'll kick in. You'll also want powers of attorney for medical decisions. So we have separate documents, one for medical and one for financial matters. The healthcare directive is going to be, this is where you state your wishes in terms of your healthcare. So if you were to have a serious medical condition where you were terminally ill, how do you want to be treated? Do you want do you want to be kept alive artificially? Do you want them to assist you with a breathing tube, a feeding tube? I mean, do you want to be on a ventilator? Like, these are all things that you have the right to decide ahead of time. And you can put those in a document so that when your family members are faced with that horrible situation, they actually have a clear statement of what your wishes are, which is going to give them peace of mind if they have to make a decision on your behalf about your medical care. And with everything that's going on with coronavirus, this is a super important document to have. And then finally, there's what I call the Kids Protection Plan. And this is a set of documents that deals with your children, your minor children. So we'll appoint permanent guardians in your will. We'll also appoint temporary guardians in case of an emergency. And we'll also create some additional documents to give guidance to those people of how you would want your kids raised if somebody ends up raising your kids. And furthermore, there's also a document where we can actually exclude people. So if there's particular family members that you think might want to step in and take over, but you wouldn't want raising your kids, you can actually create a confidential document so that those people never end up in charge of your kids. And that's all part of the Kids Protection Plan. So now I'm going to talk a little more about wills and living trusts, because in Louisiana, you can use either. And they both kind of do the same thing, right? They're both a way to transfer your assets after you die from yourself to your beneficiaries. So both of them allow you to express your wishes and say who you want to get what. But one big difference is that the will only governs things that are owned in your name. So if your house is owned in your name, your car is owned in your name, your bank account is owned in your name, all of that requires a will for you to be able to pass it to somebody else upon your death. The living trust is an entity where you can put assets. So any assets that your trust owns. So if you create a trust and then you take your house and you transfer it to the trust, and you take your car and you transfer it to the trust, and you take your bank accounts and you transfer them to the trust, those are all held by the trust. So when you die, your will has nothing to do with these assets. There's no probate, there's no succession. Just the terms of the trust govern what happens. So in that trust, you can say, I want the house to go my wife. I want the kids to get, this and that, right? You can actually be very specific. The living trust will avoid probate. It'll avoid the succession. It will also avoid interdiction if there's an incapacity, because if you become incapacitated, you can put terms in the living trust that will say that if I'm incapacitated, I want my wife to take over everything in the trust and manage it, right? So now she doesn't even need to have power of attorney. Anything that's in that trust, she can control. So it avoids probate, it avoids having to do an interdiction, and it creates a really easy way to move your assets to your heirs, because they don't have to go to court. When you die and there's a living trust, Basically they bring the trust to the lawyer's office. They look at look at what the trust says, and then they sign some papers and you're done, right? No court filings, no waiting periods, no court fees, none of that. With the will is actually something that's enforced by the probate court. So if you have things in the will that are going to go to somebody, that's great, but we still have to probate the will in order to make that happen, right? So we have to file a succession in Louisiana, open succession, file the will, get the court to look at everything, make sure it's all good, and then the court will say, okay, we can transfer the assets. In Louisiana, you are required to file a succession if you have more than $125,000 of assets at the time you die. So what I tell my clients sometimes is if you don't have a lot of assets, if you're under that 125, then a will is probably fine for you, because odds are there's not going to be a lot there to probate anyway. I mean, the living trust will still be easier, but it's not as big of a problem, right? Now, if you have lots of assets, then the living trust becomes the preferred way, because it's just going to make things easier for everyone. The other situation where a living trust is really recommended is if you own property in other states. So if you own like a beach house in Gulf Shores in Alabama, or if you own a ski condo in Aspen, or anything like that that's not in Louisiana, that's real estate. If you die with a will in Louisiana, you're actually going to have to go probate that will in an ancillary probate in all of those states in order to get those properties transferred. Whereas with the living trusts, you can just put all those things in the trust, and then it's just one transaction. We're done. It's private. It's done in the office. You don't have to file anything in court. So I hope that helps clear up like when a will would be the best move and when a living trust would be the best move. And of course, this is all general. When we we're not talking about a specific situation, but in general, this is a good rule of thumb. Now, with the living trust, of course, it's more maintenance during your life, because the key that makes the living trust work to avoid probate is that all of your assets have to be in the trust. So you actually, after you sign your living trust documents, we're going to do transfers. We're going to transfer all of your real estate into the trust. We're going to transfer all your investment accounts, all your bank accounts, all your business interests. Everything's going to go in this trust, everything you own. Because if we leave something out of the living trust, then it will have to go through a succession. And the whole point of this is not to have a succession, right? So we definitely have to be careful that we put everything in the living trust, which is why I said earlier, it's really important that you stay in touch with your attorney and that you keep us informed. Like, if you buy a new piece of property, if you start a new business, if you make changes in your assets, then we have to make sure that those assets get moved into the trust. And we make it super easy. We give you all the documents and all the sample templates of how to do it, and we pretty much walk you through it. But after you leave our office, we try to stay in touch with you to make sure that you keep this funded, because if you don't keep it funded, then it's going to fail. You have to keep it updated. Now, during your life, while you have all this property in your trust, you keep total control over these assets. So the living trust is a revocable trust. That means you can cancel it or change it at any time during your life. You can buy, sell, and manage your assets just like you normally would. It's just that instead of signing, Bob Smith, you would sign Bob Smith, trustee of the Bob Smith Living Trust. That's literally the only difference. The trust is going to have the instructions for how your assets are going to be managed if there's an incapacity or if there's a death. And it doesn't affect your rights to any of the property during life. So it's really very simple. Like I said, the only key is you have to keep all your assets into that belong in the trust at all times. So I've mentioned, I've given you some idea of what happens without a plan. I've given you some information about what you need in your plan. So you may be thinking like, okay, so what's the easiest way to get this done? And a lot of people will turn to the internet and turn to something like LegalZoom, and they'll say, oh my God, I can get an estate plan for a couple $100. Like, I'm just gonna, like, why shouldn't I do that? And there's really two reasons. First of all, one of the problems with these national online will websites is that the people that write those forms don't live in Louisiana. They're not Louisiana lawyers, and a lot of them don't understand Louisiana law. So if you take one of these forms and download it and fill it in, you could end up with a mess. Even if the forms are compliant with Louisiana, if they say in the sale, it's like, oh yeah, these are valid in Louisiana. The other problem with the do-it-yourself approach is that you may miss things, or you may not understand completely what's going on in these forms. And again, that could leave you with a big mess. A lot of times using these forms doesn't avoid probate because you're not talking to an attorney to get a customized plan, and you're not making sure all your assets are in it. So one of the things that we do in our office with estate planning clients is we make an inventory of your property, because we want to make sure that your assets don't end up in unclaimed property. We also want to make sure that if you choose a living trust plan, that all of your assets are transferred properly into the trust. The problem with those online forms is, sure, you'll get your forms and they'll send you, you'll download your documents, you can put them in a binder. But if you don't take that next step of actually funding that trust properly, it's not going to work. And so that's why we really recommend that you work with an attorney that specializes in this area, because it's going to help you make sure that that doesn't happen. A lot of these forms, they don't have the kind of comprehensive planning for your minor kids that I provide with My Kids Protection Plan product. So it's, at best, it's going to have a spot to name guardians in your will, but it's not going to cover the temporary guardians or any of the other things I talked about. And then last, it's only going to address your money. It's not going to address your other things that matter to you, like your values, your insights, your stories and experiences. The way we do planning in our office, like I said earlier, we really want to build a relationship with you and your family for the long term. So one of the things that we do for you is we work with you to create these interviews that we record. After your plan is done, you'll come in and we'll do this interview where you can talk about, why you designed the plan the way you did, or why you created a certain trust, and you can share those values, stories, and experiences, and we'll actually record it and put it on a flash drive for you, so that, the whole point of this is that after you're gone, the people who are managing your plan, they can listen to that and hear what you meant when you wrote this in this particular language in your trust, or what you wanted this trust to be used for, how you felt about certain things. And it's really great for your heirs to actually have that in your own voice. So it's not required, but we always offer it to our clients because it's really a great thing to leave behind. One of my colleagues actually, she had an experience where she had a voicemail on her phone from like a week before her father passed away, and she had kept it because she liked to hear his voice, even though it was nothing earth-shattering. It was just like a voicemail, a simple voicemail. But one day she accidentally erased it, and she was so sad because that was like a little connection she still felt to her dad, as being able to listen to that voicemail. So imagine if we could create, some more extensive recordings of you talking about these things for your kids and your grandkids. It can actually be something really valuable that you can leave behind. The other thing I'll say is that a lot of times, you will work with an attorney and get these documents done, and maybe you've done so in the past, but if they didn't take care of the funding of these living trusts, it can cause a big mess. And another friend of mine had this situation. She's also an attorney, and she had, her dad had done a plan with a very fancy law firm. It was $3,000. It had like a living trust and all this in it. So when her father passed away, she thought everything would be really easy and simple, but apparently not, because they only funded one of the assets into the trust. So there was a lot of assets not in the trust. So they still ended up having to go through probate, and it was a big mess. And that's what can happen when you don't do the whole process. You just get the documents and that's it. You really need the whole package. And here's what should be in that package. So first of all, if you're working with an attorney on an estate plan, the attorney should educate you, kind of like I'm trying to do today, as to What are your options? What are the choices? What's going to happen under these different scenarios? Estate planning is not one size fits all. It really needs to be customized to your family, your assets, and where you are in life. So that is super important. The really good estate planning attorneys, most of them charge a flat fee because they don't want you worried about minutes and hourly rate. And if I call you, you're going to charge me, so many dollars per minute. No, I don't want you to worry about that. So what we're going to do is we're going to meet. We're going to agree on your estate plan package. I'm going to quote you different fee options. You're going to pick what fits your budget and your needs. And then we're done. You can call me as many times as you want, and we will help you with whatever you need related to getting this plan done without you having to worry about surprise bills. So flat fees, I feel like, are just really important. Regular estate plan reviews, we review every plan every 3 years at a minimum. We do have other service packages where we'll review it more. But by reviewing it every 3 years, it's a good check to make sure everything is up to date, everything is funded, everything is going to work for you. The family wealth inventory is something that a lot of attorneys don't include, but I think it's so important because whether you have a trust or a will, your heirs are going to need to know what you own. And if you're not a naturally organized person with your finances, then the process that we take you through is going to make it easier for you to kind of come up with that. We'll give that to you. You can put it with your estate planning documents. And then if something happens, everything is in one place so that, if you have someone managing your affairs under a power of attorney, they'll be able to see where everything is, the passwords, where to find everything. If it's after your death and we're trying to, manage the estate and transfer all the assets, we'll know exactly what we're dealing with. Kids protection planning, I've already talked about that. Making sure that those different guardians, the emergency guardians, the temporary guardians are actually appointed and that it's the right people and that you leave behind like good guidance for the people that are going to take care of your kids. So that is a process that we take you through that a lot of attorneys just they'll just say, who do you want as your guardians and put it in your will. But we go a little deeper with that because we want to make sure it's the right people and that we exclude the wrong people and that we handle all the eventualities, not just death, but also emergency guardians. So there's a lot I've shared today about what could happen to your family if you become incapacitated or when you die. And what you've seen and I hope you've seen as a result of all these stories that I've shared, is that the typical transactional estate plan that you do yourself online or with a very transactional lawyer that's really inexpensive is going to leave you at risk, and it's going to leave your family at risk. I suspect that the reason you are listening to this workshop today is because you want to make everything easy for the people you love, and you don't want them to have to go through any unnecessary stress and time of having to go to court to settle your estate, or leaving your kids at risk of ending up with the wrong guardians. And I don't know what's most important for you based on your specific family situation, because this is a general presentation, right? So I've kind of covered a lot of things in general. And you may be wondering, well, does that really apply to me? What do I really need? How much is this going to cost me? And what I'm going to tell you is that is the reason that when I work with clients in estate planning, I always start with this family wealth planning session. And what I'm going to do right now is invite you to schedule one, you and your spouse, to come in and schedule one of these family planning sessions with me. And I'm going to tell you a little bit about what we do. So this is a working session. It's usually about 1 to 1.5 hours, sometimes up to 2 hours, depending on how many assets and how complicated your situation is. And we really spend that time. First, we look at all of your family dynamics and we look at your assets. We look at the specifics. We look at all the little things that make your family unique. And then we kind of go through the process of figuring out, okay, so what's going to happen on incapacity? What's going to happen upon death? How are we going to make sure that we get a good result for our family that makes things easy for them? And at the end of that discussion, we're going to help you figure out what is most important to you about this process so that we can recommend the best plan for you. Normally, because it is a lot of my time and yours, we charge $750 for these sessions. Like I said, it's like 1 to 2 hours. We do these usually in person, but because of coronavirus, we're doing these by Zoom. And at the end of that session, you're going to be super organized. You're going to have an inventory of all your assets, so nothing gets lost as anything happens to you. We're going to look at everything that would happen, and you're going to tell me what's most important. And based on that, I'm going to help you choose the right plan for you. We have 3 levels of planning, and our average fees for families range between $2,000 and $8,000 flat fee for your plan. And where you fall along that range really depends on your budget and what you want for your family. Everything is going to be flat fee, agreed in advance. We're going to be very transparent with how the fees work, so you're going to know what you're getting into. You're going to make your decisions, and then we're going to give you a price. You're going to choose the plan that's right for you. So you're going to have that clarity of knowing that it's going to work for your family. So I'm going to make it really easy for you. I am actually going to give you, as a thank you for being on the workshop today, I'm going to give you the family wealth planning session for free, and that's a $750 value. And all you have to do is meet 2 conditions. I want you to go ahead and schedule. You can go to wealthplanmeeting.com, and there should be a link under the webinar video where you can click, or you can just type in wealthplanmeeting.com into your browser. And then I want you to commit to do the homework. So what's going to happen when you click on the link, you're going to go to my calendar and you're going to be able to pick a time. Once you pick a time, there's going to be a little form you'll fill out that has some basic information about you and your family. And then you're going to get a confirmation email back from me that says your appointment is confirmed. And it's going to have a link to a form for you to fill out online. It's also going to have a PDF attachment if you prefer to fill it out that way. Print it out and fill it out in ink. That's fine too. But either way, I'm going to want you to fill out this and this form is a family wealth planning inventory. And this is what we use to help you get your assets organized. It is a big document, so you may feel a little bit overwhelmed when you first see it, but it's really for your own benefit, because it's going to help me really understand what your estate looks like and what I should recommend to you. And it's also going to help you because once you do it, you'll have your assets all organized for your family. So filling it out really helps us make the most of our time together. So what I want you to do right now is, if you're ready, just go ahead and click wealthplanmeeting.com and book a time. And if you want to think about it or talk to your husband more about it, or your wife, that's fine. However, if you go ahead and book it today, I'm going to give you an additional $250 credit off of your plan. So whatever planning we end up doing for you, you're going to get $250 off. And so I'd love for you to just go ahead and schedule. There's nothing to lose. Like I said, I'm not charging you anything for the session. It's a value of $1,000 if you go ahead with it. So fill out the form. You'll get your inventory homework by email. And yes, if you need help filling that out, if you're confused, then call our office or email us. We're happy to walk you through it. And then one more thing I'll mention is, if you have, most of the appointments you're going to see on my calendar are between 9 and 5. But if you have a situation where you really need an evening or a weekend appointment, I can do those as well. But those are very limited. So what I'm going to need you to do is to email me, and that information will be in the follow-up email that you get. And then I will get you scheduled. We'll try to schedule you for a weekend appointment. So of course those are limited. So if you want one of those, let me know ASAP. So again, here's where you can go, wealthplanmeeting.com. There should also be a link in the webinar platform that you can go to. So if you have any questions at all, feel free to email those to me, or call my office at 225-465-1090. Click the link if you want to schedule a meeting. Thank you so much for your attention today, and I really look forward to helping you take care of your family. Thanks.